So we're going to move on to some other federal laws regarding patient protection and privacy. So FERPA has a very nice video describing FERPA, which I think is really well done. Essentially, it is an act that protects the privacy of information for students in schools, and in particular for those PTAs and PTs who work in schools. This is a fundamental piece of protection for their patients' health records as well as educational records, and it also protects you as college students. So the only people that have written permission to release any information regarding student health records is incredibly limited, but there are parties within the school system that information can be shared. So if, for example, if you are a PTA and you're going to be seeing a student in a school setting, you do have the right to access information about the generalities, about the age of the student you're seeing, some information from the IEP, or Individualized Education Plan, which can include health condition, and information related to perhaps some speech or language challenges, or some health conditions related to learning environment. So you're prepared to see that person because you have that information. You also can access, who is seeing that individual in other teams and who has been working with them, and also, for example, what time their bus shows up. That's important information if you are working with somebody who is accessing the community in a chair, so you can work with the bus driver, for example, on helping that perhaps with if the student is complaining of back pain that occurs after their bus ride, there could be, and if the bus driver is helping secure the student in the bus, perhaps the straps are too low or too loose and aren't positioned properly, so you have an opportunity to work with that bus driver on how to adjust the methods that are used to secure the student in the bus. So that's important information. And certainly, as your students, accrediting organizations, as CAPTI, we're not releasing information about you personally as students, but we are releasing information to CAPTI in order to keep the doors open, such as information about the overall graduation rates and success students pass the first term, the percentage-wise, for example. And certainly to access information on who to contact in regards to an emergency, if something's happened to you and all we have is your cell phone number, accessing information and working with public safety to get a hold of appropriate emergency contacts. And the same would be the case if you're working with a student in a K-12 setting, or working with college students with disabilities. So the next thing I'm going to talk about is the HIPAA, and you'll be learning about HIPAA next term also in PTA 103. But the important information about HIPAA is that, and it's the Health Insurance Portability and Accountability Act. It's HIPAA, not HIPPA, which is a common mistake. It was passed specifically to, actually the intent of the law is interesting. There's several facets to it. People were getting tired of having their health information shared with marketing companies. And so, for example, if you were a newly diagnosed diabetic, before HIPAA was passed, your information regarding being on insulin or using test strips was being passed on to marketers, and so you were being solicited, often even before you went home from a hospital stay, by aggressive marketing companies. who are accessing your information. So the beauty of this act is that you only access information of a patient that you are currently seeing. And it also prohibits you from looking up and snooping on information regarding friends that may be in the hospital that you are working at. Not that you would do so maliciously, but sometimes maybe you want access to see what room they're in. You can't do that. You can't do that. You can only access information for people that you are actively seeing as the clinician. And that is really, really important. You have to protect that information by not bringing files home, by not putting information about the patient on the internet, social media in particular. You cannot put anything on social media about patients, and even generalities of like, oh, I saw this patient today, it was really cool, he had T4 spinal cord injury. Okay, well, great, you just published information about your patient, and perhaps you work in a small town and people start, your friends on Facebook or Instagram or Twitter or whatever you're using, say, oh, I wonder if it's Bob. You've heard about Bob in that automobile accident. Was that him? How's he doing? You only would, here's the thing, I thought this was really good. It was published by a PT that said, if you cannot put in social media that you would not be able to share with anybody in an elevator or in any public space. So in other words, if you are sharing anything about someone you're seeing outside of that specific treatment area where you are seeing that patient and with that PT that is supervising you or other healthcare provider that has an interest in that same patient, such as another therapist, speech therapist, social worker in some cases, you can't talk about that on social media. And I just mention that because this is where people are getting into trouble today, is violations of HIPAA, and people are getting fired for doing so. And that's serious. That's a fireable offense by your institution and actually is grounds to lose your license under the Oregon Physical Therapist Licensing Board rules and regulations that you've learned about. And I think that's all I'm going to talk about that. The rest of the information is pretty explanatory and actually quite well done.